My name is Rosie, and I never imagined my marriage would end inside a courtroom. When I filed for divorce, I thought it would be painful, but fair. What I didn't expect was to sit there while my own wife stood in front of a judge and declared that I was mentally unstable. He's not fit to manage finances. He's paranoid. He's delusional, she shouted. The courtroom murmured. I sat quietly.
Calm.
Because the truth doesn't panic. What she didn't know was that every accusation she was making was about to collapse under one simple question from the judge. A question that would change everything. Do you know what that diagnosis actually means? That was the moment the narrative shifted. This isn't just a divorce story. It's a story about manipulation, reputation, and what happens when someone weaponizes mental health in court without realizing the law requires proof. And proof was something I had prepared long before she raised her voice. Absolutely. Here is part 1 expanded to 400 words, deeper tension, stronger courtroom atmosphere, focused on Rosie.
Part 1, the accusation.
The courtroom felt colder than it should have. Not because of the air conditioning, but because of what was about to happen. Rosie sat across from me, perfectly composed. Navy blazer, hair neatly pulled back.
Calm on the outside.
Strategic on the inside. If someone walked in without context, they would think she was the victim. When the judge began reviewing standard divorce matters, asset division, property valuation, temporary custody terms, everything felt procedural. Predictable. Then Rosie's attorney stood up. Your Honor, he said carefully, before we proceed further, my client has serious concerns regarding her spouse's mental stability. The room shifted. Subtly but unmistakably. The judge looked up. Clarify. Rosie stood. Her voice trembled slightly, convincingly.
He's not well, she said.
He isolates himself for days. Talks to himself. Obsesses over financial records. He's paranoid. I'm afraid he's not mentally fit to manage our shared assets. The words echoed heavier than they sounded. Mentally unfit. That phrase doesn't just float in a courtroom. It lands. Hard. A few people in the gallery turned their heads toward me. The clerk paused mid-note. Even my attorney's posture stiffened. Rosie continued. He's unpredictable. He imagines things that aren't there. He thinks I'm plotting against him. There it was. The narrative. Carefully constructed. But she left out something critical. Context. Because yes, I had been reviewing financial records. Yes, I had been documenting withdrawals. Yes, I had been cautious. But caution isn't instability. Preparation isn't paranoia. And documentation isn't delusion. The judge leaned back slightly, studying both of us. Do you have medical documentation supporting this claim? Rosie hesitated, just for a fraction of a second. We believe a psychiatric evaluation is necessary, her lawyer answered instead. Necessary. Meaning they didn't have one. And in that subtle gap between accusation and evidence, I realized something. This wasn't concern. This was strategy. And strategy without proof is a very dangerous thing to attempt in front of a judge. The judge turned his attention toward me. Would you like to respond to the allegations? The entire room felt suspended in that question. Rosie was still standing. Her hands were lightly clasped, her expression carefully arranged somewhere between worry and fear. It was convincing, I'll give her that. But emotion only carries weight in court if it's backed by evidence. I stood slowly. No sudden movements. No raised voice. Yes, Your Honor, I said evenly. I would. I didn't look at Rosie. I looked at the judge. I strongly deny any claim of mental instability. I have voluntarily attended counseling during our marital difficulties. I also have independent psychological evaluations conducted within the past year. That sentence changed the atmosphere. Rosie's shoulders stiffened slightly. Her attorney glanced sideways at her, a subtle flicker of confusion. Independent evaluations weren't part of her script. My lawyer stepped forward and handed a neatly organized folder to the clerk. Certified reports. 2 licensed psychologists. Separate consultations. Both conclusions were clear. No clinical diagnosis. No signs of paranoia. No cognitive impairment. What was noted instead? Heightened stress due to marital financial conflict. That's not mental illness. That's situational strain. The judge skimmed the first page, then the second. His expression didn't change, which, in a courtroom, is usually a good sign. "Ms. Rosie," he said calmly, "were you aware of these evaluations?" Rosie blinked. No. I didn't know he had done that. That hesitation mattered. Because if she truly believed I was unstable, wouldn't she have encouraged evaluation? Wouldn't she have known? Instead, she had presented suspicion, not documentation. I spoke again, carefully. "Your Honor, I began documenting financial discrepancies several months ago after noticing unexplained transfers from our joint accounts. My record-keeping behavior has been characterized as paranoia." The word hung there. Paranoia. Or preparation. The difference between the two often depends on proof. And I had brought mine. For the first time since the hearing began, Rosie wasn't controlling the narrative. The room had shifted. And this time, it shifted toward facts. Balance scale. When the psychological reports were entered into record, the courtroom energy shifted, but it didn't settle. Because this wasn't just about whether I was stable. It was about why I had been documenting everything in the first place. My alleged paranoia, I continued calmly, began after I discovered irregular financial activity in our joint accounts. Rosie's attorney immediately stood. Objection, relevance. My lawyer responded smoothly. Relevance directly tied to motive behind alleged behavior. The judge nodded. Proceed. I handed over a second folder. Bank statements. Highlighted transactions. Dates circled carefully. Over the past 8 months, there had been repeated withdrawals, large ones. Transfers to accounts I didn't recognize. Credit card payments for expenses I had never seen. Individually, they might have looked ordinary. Together, they told a pattern. The judge reviewed the summary sheet. "Ms. Rosie," he asked, "were these transactions disclosed to your spouse?" She shifted in her seat. "I handle most of our finances. He worries too much." That wasn't an answer. The judge repeated, slower. "Were they disclosed?" "Not specifically." That silence was louder than her earlier accusations. I spoke again, measured. "When I noticed the withdrawals, I requested clarification. I was told I was overreacting. So I began keeping records. That record-keeping has now been described as delusion." The courtroom was quiet. Even the clerk's typing slowed. Because what Rosie had framed as instability now had context. If someone discovers unexplained money transfers, documents them, and seeks clarification, that isn't paranoia. That's due diligence. The judge leaned back slightly, fingers folded. "So, your documentation behavior began after discovering undisclosed financial transfers?" "Yes, Your Honor." "And you sought counseling during this period?" "Yes." Not secretively, not defensively, responsibly. Rosie's confidence was no longer steady. Her initial performance had relied on emotion. But emotion fades when evidence enters the room. And now, the narrative was no longer about my mental state. It was about accountability. The accusation that was meant to discredit me was beginning to expose something else entirely. Balance scale. The courtroom had gone from tense to analytical. At first, Rosie's accusation had landed like a dramatic blow. Now it sat on the table dissected. The judge adjusted his glasses and looked directly at Rosie. Not harshly, not emotionally, just carefully. "Ms. Rosie," he began, "you've alleged that your spouse is mentally unstable." She straightened slightly. "Yes, Your Honor." "You described paranoia, delusion, and unfitness to manage finances." "Yes." He paused, just long enough for the silence to grow uncomfortable. "Do you know what constitutes a clinical diagnosis of paranoia?" The question wasn't loud, but it hit harder than anything said so far. Rosie blinked. I just know what I've experienced." "That was not my question," the judge replied calmly. He leaned forward slightly. "Do you understand that in this court, alleging mental instability requires medical evidence? Not personal frustration. Not interpretation." Her attorney shifted beside her. The judge continued, Voice steady but firm. Do you understand the legal consequences of falsely alleging mental illness in order to influence asset division or custody matters? That was the moment her confidence cracked. Because this was no longer about emotion. It was about liability. I wasn't trying to lie, Rosie said quickly. I was concerned. The judge nodded slightly. Concern leads to evaluation. Allegation requires proof. He held up the certified psychological reports that had just been submitted. These evaluations show no diagnosable condition. None. The courtroom felt still.
Heavy.
And yet you presented this as fact. Rosie swallowed. The difference between suspicion and sworn statement had finally become clear to her. When you speak in court, your words don't float. They record. The judge placed the papers down. This court will not entertain unsubstantiated psychiatric allegations. If further claims are made without documentation, sanctions may apply. Sanctions. That word changed everything. Because now, the risk wasn't mine. It was hers. The accusation meant to destabilize me had just put her credibility under judicial scrutiny. And once credibility cracks in court, everything else begins to unravel. Balance scale. After the judge's warning, the courtroom didn't relax, it sharpened. Because once credibility is questioned, motive becomes relevant. My attorney stood calmly. Your Honor, we believe the timing of these allegations is not coincidental. Rosie's lawyer immediately objected, but the judge allowed limited questioning. Proceed carefully, he said. My attorney turned toward Rosie. Ms. Rosie, isn't it true that if your spouse were declared mentally unfit, you would gain sole control over joint financial accounts pending further review? Rosie hesitated. That's not why I... Please answer yes or no. Yes. The word barely left her mouth. And isn't it also true that you requested exclusive financial authority in your preliminary filing? Another pause. Yes. The pattern was forming. This wasn't just about concern. If I had been labeled unstable, control of shared assets would have shifted immediately. Decision-making authority. Access. Influence. The judge's expression didn't change, but he was listening very carefully now. My attorney continued. Did you consult a medical professional prior to filing these claims?
No.
Did you seek emergency psychiatric evaluation?
No.
Did you ever request marriage counseling together before filing?
No.
Each answer chipped away at the narrative. Because genuine fear leads to action. But this had been paperwork first. The judge folded his hands. Ms. Rosie, this court takes mental health allegations extremely seriously. They are not strategic tools. They are medical matters. Strategic tools. That phrase lingered in the air. Rosie's composure was slipping now. Her voice no longer steady. I was scared, she said quietly. Of what? The judge asked. She glanced briefly at me. He was documenting everything. There it was. The real issue. Not instability. Accountability. The judge made a note. And in that moment, the narrative flipped completely. The question was no longer whether I was unstable. It was whether the accusation itself had been tactical. And in a courtroom, once motive is exposed, the balance of power changes instantly. Balance scale. Once motive entered the discussion, the tone of the hearing changed completely. This was no longer an emotional divorce dispute. It was a credibility examination. The judge requested both attorneys approach the bench briefly. A quiet exchange followed, procedural, but serious. When they returned, the judge addressed the courtroom. Given the nature of the allegations and the financial discrepancies presented, this court will proceed with heightened scrutiny. Heightened scrutiny. That meant every statement from this point forward would carry weight. Rosie was asked to take a reaffirmed oath regarding the truthfulness of her claims. She swallowed before repeating the words. Because now, if she continued pushing the instability narrative without proof, it wouldn't just be weak, it could be perjury. My attorney stood again. Your Honor, we request the court review the timeline of events. A chart was displayed. Month 1. Unexplained withdrawals begin. Month 2. Spouse questions transactions. Month 3. Spouse begins documenting. Month 5. Divorce filing initiated. Month 6. Allegations of instability introduced. The sequence was clean. The judge looked at Rosie. Your concerns about mental health arose after financial disputes? She hesitated. That's when it became obvious. Obvious to whom? Silence. The room felt tighter now. Because what was being tested wasn't just evidence, it was consistency. Earlier, Rosie described long-term instability. But the timeline didn't reflect long-term concern. It reflected escalation after financial questioning. The judge made another note. This court is not convinced that sufficient evidence exists to support the requested psychiatric review. That sentence landed heavily. Because without that review, the foundation of her strategy collapsed. But the judge didn't stop there. Furthermore, the court is ordering a temporary financial transparency audit of joint accounts. Now, the spotlight shifted fully. From my mental state to her transactions. For the first time since the hearing began, Rosie looked uncertain. Not dramatic, not emotional, uncertain. Because in trying to label me unstable, she had triggered a deeper examination. And examinations don't stop once they start. In court, accusations are like doors. Once opened, the room behind them must be inspected. Balance scale. Court-ordered audits are different from casual financial reviews. They don't glance.
They dig.
Within 2 weeks, a forensic accountant was assigned to examine our joint accounts. Every transfer, every withdrawal, every linked account. The hearing reconvened once preliminary findings were submitted. This time, Rosie didn't look as confident walking in. There was no dramatic posture, no raised voice, just tension. The forensic accountant took the stand. Between January and July, he began, there were multiple transfers from the joint account to a secondary account ending in 4821. My attorney asked, was that secondary account listed as jointly owned? No, the accountant replied. It is registered solely under Ms. Rosie's name. A quiet ripple moved through the courtroom. The accountant continued. Total transferred amount, $84,300. The number hung there. Rosie's attorney stood quickly. Those funds were used for household expenses. The accountant adjusted his glasses. Household expenses were already being paid from the joint operating account. These transfers were categorized under consulting services and private allocation. Private allocation. The judge looked at Rosie. Do you dispute these findings? Her voice was softer now. I intended to repay it. Repay. That word mattered. Because repayment implies acknowledgement of withdrawal. And withdrawal without disclosure, during active divorce proceedings, signals something else entirely. The judge remained composed. Why were these transactions not disclosed when concerns were raised? Rosie hesitated again. I didn't think it was necessary. Necessary. The same word she used when requesting psychiatric evaluation. Only now it sounded hollow. My attorney didn't need to say much. The pattern spoke on its own. Financial questioning had led to documentation. Documentation had led to tension. Tension had led to accusations of instability. And now, the audit revealed undisclosed transfers. The narrative had flipped completely. The court wasn't evaluating my mental state anymore. It was evaluating her credibility. And credibility, once weakened under oath, is incredibly difficult to restore. The judge closed the file slowly. This court will continue review. Short sentence. Heavy meaning. Because in legal proceedings, the most dangerous moment isn't when someone shouts. It's when the evidence speaks quietly and no one can interrupt it. Balance scale. When the hearing resumed after the audit summary, the atmosphere was no longer dramatic. It was procedural, which, in court, is far more dangerous. The judge reviewed the forensic findings once more before speaking. This court finds insufficient medical evidence to support claims of mental instability, he began.
Clear. Direct.
Final on that matter. Rosie's original strategy, to push for psychiatric review and financial control, had officially collapsed. But the judge wasn't finished. Given the undisclosed transfers identified during the audit, the court is ordering temporary restrictions on unilateral financial withdrawals by either party. Temporary restrictions. That meant no one could move funds without dual authorization. Control would not shift to Rosie.
Control would not shift to me.
It would remain supervised, balanced. Rosie's shoulders tightened. She hadn't expected that. The judge continued, voice measured. The court also notes that allegations of mental instability were presented without supporting medical documentation. While sanctions are not being imposed at this time, the court strongly cautions against future unsubstantiated claims. Strongly cautions. That was a judicial warning. Not public humiliation. Not punishment. But a clear signal. The court had taken notice. Rosie nodded quietly. Her earlier certainty had dissolved into controlled silence. My attorney leaned toward me and whispered, "That's a turning point." He was right. Because the legal leverage she attempted to gain had not only failed, it had triggered oversight she couldn't control. The focus had shifted entirely. From my supposed instability to procedural fairness and financial transparency. The judge concluded the session with one final statement. This matter will proceed toward equitable resolution based on verified evidence. Verified evidence. Not accusations. Not emotional testimony. Evidence. As the courtroom began to empty, Rosie avoided eye contact. For the first time since the proceedings began, she wasn't leading the narrative. She was reacting to it. And in legal battles, once you lose control of the narrative, you lose control of momentum. The next hearing would determine asset division. But the outcome already felt clearer. Because the foundation of her strategy, doubt, had been dismantled. And doubt, once disproven, rarely rebuilds itself. Balance scale. Now we reach the final stretch, where the court makes it official. Balance scale fire. Here's Part 9, expanded 400 words. Part 9, the final hearing. The final hearing felt different from the first one. There was no dramatic entrance. No raised voices. No sudden accusations. Just paperwork. Evidence. Procedure. Rosie sat quietly beside her attorney, no longer projecting certainty. I noticed something else too. She wasn't making eye contact with the judge anymore. Because credibility, once questioned, changes posture. The judge opened the session by summarizing the case. This court has reviewed allegations of mental instability, psychological evaluations, and a court-ordered financial audit.
He paused slightly.
The evidence does not support claims of mental unfitness. That sentence officially closed the chapter that had begun with her shouting, "He's mentally ill." It wasn't dramatic. It was factual. Then the judge shifted to asset division. The forensic report had already clarified the undisclosed transfers. The $84,300 withdrawn from joint funds would be considered in the final distribution. In light of the audit, the judge stated, the undisclosed transfers will be credited toward equitable distribution. In simple terms, the money Rosie moved would count against her share. Her attempt to gain financial advantage had quietly backfired. The judge continued calmly. This court emphasizes that allegations of psychiatric instability require medical substantiation. Legal proceedings are not venues for strategic character attacks. That line felt heavier than any financial ruling, because it wasn't about money anymore. It was about record. Court transcripts matter. And now the official record showed. No diagnosis. No instability. No justification for her claim. The divorce decree was finalized shortly after. Assets divided fairly. No psychiatric review ordered. No sanctions imposed, but a formal warning documented. As we stood to leave, there was no celebration. Just closure. Rosie gathered her papers slowly. For the first time since this began, she looked uncertain rather than defensive. I didn't feel victorious. I felt clear. Because what began as an attempt to discredit me had ended with a court confirming the opposite. And sometimes that confirmation is more powerful than revenge. Balance scale. After the final ruling, life didn't explode into relief. It just settled. The divorce decree was stamped, signed, and entered into record. Assets divided. Financial credits adjusted. No psychiatric evaluation ordered. No legal penalties imposed, but a clear judicial warning documented. That documentation mattered. Because when someone stands in court and declares you mentally unstable, it doesn't just sting emotionally. It threatens your reputation, your credibility, your future opportunities. The judge's written summary included a single line that meant more than anything else. The court finds no substantiated evidence of mental unfitness. Simple.
Direct. Permanent.
That sentence now lived in the official transcript, exactly where her allegation had once echoed. Rosie left the courtroom quietly that day. No final words. No dramatic glance. Just a closed folder and lowered eyes. I didn't hate her. I understood what had happened. Fear mixed with strategy can push people into reckless decisions. But the law doesn't measure fear. It measures proof. In the months that followed, I realized something important. The most dangerous accusation in a legal setting isn't about money. It's about sanity. Because sanity questions character, judgment, capability. And once that's questioned publicly, you don't defend it with emotion. You defend it with documentation. Looking back, the turning point wasn't when she shouted, "He's mentally ill." It was when the judge calmly asked, "Do you know what that diagnosis requires?" That question stripped the emotion away and exposed the gap between assumption and evidence. I didn't win because I argued better. I didn't win because I was louder. I won because I prepared before I needed to. And in a courtroom, preparation beats performance every time. This story isn't about humiliation. It's about responsibility. Mental health is serious. It's real. And it deserves respect, not weaponization. If you ever face public accusations, remember this.
Stay calm.
Stay documented. Stay factual. Volume fades. Records remain. And when the judge asks, "Do you know?" make sure the answer is backed by proof. Balance scale.